Hi, my name is Miles LeBaron. I'm an estate planning attorney with offices in Layton and Ogden, Utah. And my practice in the estate planning arena focuses on planning for your death. I recently had a 48-year-old client die in a motorcycle accident, and it's really shocked me into the awareness that everyone needs to plan for the inevitable. One of the questions that a lot of people ask when they're doing their estate, or when they're thinking about estate planning, is what is an estate plan? And they start hearing about wills and trusts, and they're confused about what those different animals are. And so today I want to talk a little bit about the will versus the trust. A will is a written document, as is a trust, and they both help you plan for your death. The will, though, has some inherent problems associated with it, and those problems are fixed when you do a trust. Now, there is a little bit of an additional expense associated with a trust, but that additional expense is far less than what you would pay if you pay for a will initially. The reason for that is that when you put together a will, there's that initial expense of putting together the will, but then you also have to pay for probate after you die. And if that's a concern for you, that your estate or your children will be having to pay for probate, if you get an attorney, and I would recommend that you get an attorney, is going to cost anywhere between $2,000 and $3,000 before you're done. Whereas at LeBaron and Jensen, our trust package is $750, and so the initial expense is a little more than the will package, but overall your expenses are far less. Now, the thing that a trust does for you is it avoids this probate process, so it avoids the court being involved. And because the court is involved, you have the hassle of filing fees and paperwork that you've got to fill out, and you've got to meet certain requirements. You got to jump through all these hoops with the court, and it can be frustrating and time-consuming and expensive. So the first thing that a trust does is it avoids that probate process. Another problem that people experience with wills is they may have multiple probates if they own property in different states. Whereas with a trust, you can handle the disposition of that property in all these different states without probates in each and every state where you have property. Another thing that a trust can help with is to avoid conservatorship or guardianship issues. A common example of conservatorship or guardianship is Britney Spears recently, where she went a little nuts, and mom and dad had to step in and take over with the court involved. That same thing can happen with old people when they get old and they get dementia or Alzheimer's, and their children have to step in and take over with the court involved. The trust is set up so that the trustee of the trust, the person who was left in charge, can take over the financial aspects of your estate, and without getting the court involved, hopefully. Sometimes if things don't work out, then it may still require a conservatorship or guardianship, but with proper planning, you've already set up who's going to be that person that will be the guardian and the conservator of your estate. Some other things that the trust does as opposed to the will is it allows for privacy. When you file a probate, your business is a matter of public record. Now, people would have to know where they were going to get that information, but it is a public record that people could get that information if they wanted to. Finally, it allows for quicker distribution of assets. When you put your property in a trust, instead of waiting for a court order to allow them to dispose of the assets, the trustee can immediately put the property up for sale, or if it's real estate or tangible assets, or go down to the bank and withdraw funds. It's almost an instantaneous thing for a trust, whereas the will takes all that time with getting what's called the letters testamentary from the court, the authority for the personal representative to act. So my general philosophy and my general recommendation as an estate planning attorney is to pay a little bit of extra for a trust package and avoid all the headaches that are associated with a will.